Okay, good evening, everybody. Please stand for the flag salute. Pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I hereby announce that this meeting is being held in accordance with Chapter 231 of the Open Public Meeting Act. Proper notice of the meeting dates has been given to the Morris News Feed and the Morris County Daily Record and posted on the bulletin board in the Borough Hall. This meeting is a judicial proceeding. Any questions or comments must be limited to issues that are relevant to what the board may legally consider in reaching a decision, and decorum appropriate to a judicial hearing must be maintained at all times. Roll call, please.
Mr. Alderman?
Present.
Mr. Garavaglia?
Present.
Mr. Bezel?
Here.
Ms. Steckert? Present. Mrs. McCluskey?
Here.
Mrs. Kelly?
Here.
Mr. Kelly? Mayor Carr?
Here.
Yes, present.
Okay, some of you were here last meeting, and so before we start, I just want to introduce our professionals so all of you know who they are. We have our attorney here is Elise Hubbard. Andy Brewer could not be here tonight, and Elise works for his firm. Our engineer is Bill Ryden, and our planner is Liz Lahaney. Not here tonight, who was here last month, is Harold Maltz. He's our traffic engineer, but he is not here tonight. So first thing, we have comments from the public on matters that are not on the agenda. Does anybody have any comments? Yes. Please come up and state your name and address.
Hello all. Frank Main, Bravidi, 35 Janeway Place. The subject is a quick one. It has to do with stormwater flow from 201 Table Road, the warehouse property. And in particular, the stormwater that comes from the roots of the building that ends up going under Greenwood Avenue and ultimately to Johnson Road, where there has been flooding. And there are flow controllers there. They're called orifice grates, and they limit the flow to 336 gallons per minute, which is a lot of flow in itself. I think we have no ability to inspect these, or no law or guidance that we can go down and inspect in the manhole these facilities, and I think we should have the ability to do that. There's likely to be a bypass valve, for example, and these grates can erode and allow more water, although that would take some time. But I think we should have such an ordinance. I don't think anyone else in town has a controlled stormwater flow like that, excuse me, so that you could make it generic to non-residential properties with stormwater control. Thank you.
Bill, do you want to address any of that?
No, Madam Chair, this is not a matter for the planning board. This application is no longer in the jurisdiction of the board. It's in the jurisdiction of the borough engineer and the borough administration. And if Mr. McAvee has any particular concerns with the project as it's developing and being built, I'm more than happy to have him call me, visit me at my office, or visit me at the site.
I left a message for you.
I had the message. I was out of the office all day.
I know you're busy.
Thank you.
Okay, so we'll talk?
You call me anytime you like.
Sure. Thank you.
Sir, if there's anything you want to do as far as suggesting an ordinance, that would be the council, would be more appropriate body.
Right, but I'm just checking the technical.
I'm just advising,
Right,
that's
so
fine.
step one is, are the technical statements I made concerning the orifice grates and whatnot correct?
Fair.
And then I go to the council. Thank you.
Thank you.
Are there any other comments from the public on matters that are not on the agenda?
Yeah.
Okay. So
my name is Lisa Schroeder. I've got some questions, process-related questions, if that's within scope of what's appropriate for this portion.
What type of questions?
Just general process. So I've been in Morris Plains for about 9 years, trying to get a little more understanding of how things get done here. So I just have some very general process-related questions.
Well, I'll tell you what, so before we start these applications, I'm gonna give everyone an overview of how this process works, okay?
Okay.
And then, is that what you want? You wanna know how
Sure.
it works?
Maybe I can just go ahead and ask the questions, and then maybe if you could address them during your comments? Would be okay?
All right, go ahead.
Sure, okay. It's really just for my own understanding about how things are done. So first of all, on the timing, I was surprised that the agenda for tonight's meeting was just posted on Friday. Thinking about things like public hearings where there might be a strong public interest, is there a certain minimum amount of notice that's given for the agendas and the timing for those meetings? That would be the first one. My other question, also from a process standpoint, is when experts are put forth by applicants to provide testimony during these public hearings, I'm curious to learn more about what opportunity the public has to respond to that testimony.
We're gonna cover that.
Okay, great. Curious about whether Morris Plains makes recordings or transcripts of planning board meetings available.
Absolutely,
To the
everything
public?
is on a tape.
Okay, great. And then my final question is, curious about to what extent Morris Plains does its own independent assessments to confirm the credibility of assessments that are put forth by applicants,
The assessments,
like traffic studies, for example.
okay.
So I'm just curious to what extent, obviously, when somebody's putting forth an application, they're gonna have a certain goal in mind. I'm just curious to what extent the town sort of checks their work.
Well, we do,
To confirm.
whatever experts the applicant has, we would hire our own expert, okay, to review whatever documents, whatever proposals they have.
But it's simply a review and not an independent assessment of our own.
Well, no, it is,
Okay,
yeah,
We have a traffic engineer on staff here.
Yeah.
okay,
That
so
the
we
borough-
conduct our own traffic studies then?
Yep.
Okay,
and, for anything else, for environmental stuff, anything like that, we have our own experts that are on call for any of those applications.
okay, great,
Okay?
thank you.
Correspondence and bills. Susan, do you have any correspondence?
Yes, Mrs. Coffey received on Sunday, July 14th, an email from Ellie Falco at 20 Jackway concerning McDonald's application.
Okay, thank you. And we have no bills tonight. So we'll move on to the approval of minutes of the June 17th, 2024 meeting. Are there any corrections or additions?
Mr. Drusler asked for a correction, second to last paragraph on page 329, to remove "and will provide."
So that will read, Mr. Drexler stated he has a more recent copy, period.
Period.
Okay. Are there any other corrections or additions? Hearing none, could we have a motion to approve the minutes?
So moved.
Second? Second. All in favor? Opposed? Abstained? Okay, the minutes have been approved.
Excuse me, who was first and second?
First.
So, first on our agenda is the application of Joan Miller Pitchery. And Mr. Boyakis, you wanna come up? We're going to,
Sure.
Ms. Hubbard is going to read the resolution.
Sure. I don't see it, I don't have a copy of it. I might be able to get one to follow along.
Yeah, here.
Thank you so much. There was one issue that arose after our last meeting, minor though it may be, and that has to do with Mr. Ryden's June 3rd report. Under his comment section, he indicated that a site triangle easement must be provided. So Mr. Anderson, our professional, I guess he went out and did some calculations, and then he spoke to Mr. Ryden, And he said, I don't really see how we need one. And apparently, and Mr. Ryden can correct me if I'm wrong, Mr. Ryden agreed that, yeah, you don't really need one. And so I had sent an email to Mr. Ryden and also to Mr. Brewer saying, hopefully that would not be a requirement under the resolution, because it doesn't seem like it's needed according to all the professionals. And that's the only comment that I have.
Okay, so when we get there, let's make
Okay.
that correction.
I don't think it's a condition.
It's not,
But
okay.
we'll see for this weekend.
I don't see it separately as a
It's
condition.
indirectly a condition because it refers to the comments in my report.
Okay.
That they'll comply with those comments, which includes that site. And I can state for the record here, I did review the particular intersection. It does not need a site easement. But I told Mr. Boyatis, I don't have the authority to eliminate that from the conditions. That would have to be an amended resolution here by the board.
Pull from the board and see if they want to remove it.
Yeah.
We could
Yeah.
add, within the conditions, we'll just see.
I think you can note that the conditions in my June 3rd, I think, report, whatever the date was, except item
3.
whatever it happened to be.
Is this under number 2, variance relief?
No, it's under 3, well,
Okay.
I'm sorry, it's under, well, after 1 and 2 on page 3, there are comments. There are 3 comments. It's the 3rd comment, the last one.
Mine might be a little
Yeah,
different.
mine's
Because
Mr.
it's-
Mine's the letter and theirs in legal, so.
I'm referring to my letter.
Right.
In
Oh,
three,
so-
in 3A, it says has the June 3rd
Yeah.
report in it,
So we could make it an exception there, where it actually says, except as otherwise stated in testimony,
Except for item 3, in my June 3rd.
Right.
In that said report.
or otherwise stated in testimony. So the condition would read, the applicant shall comply with the May 9th, 2024 report and the May 3rd, 2024 report of the board engineer. See, it's confirmed in writing by the board engineer, except for item number 3 from Mr. Ryden's June 3rd report, or as otherwise stated in testimony.
Actually, you gave me this tree ordinance, which.
I didn't give you anything.
Oh, that's Kathy.
Somebody had it, something. Where's that?
I think I have an extra copy that you could actually keep, sir. Let me see what I have here. No. And that's also true. So you want to follow along.
Okay. No, that's it.
This is a resolution for minor subdivision approval of variances. Planning of Board of the Borough of Morris Plains for application number PB-02-24. The applicant is Joan Miller Chicory. Did I say that?
Kachuri.
Kachuri, okay, we're gonna try to not forget that. Executrix of the estate of Grace Miller for the premises of 39 Hawthorne Avenue, Block 38, Lot 1. Whereas Joan Miller Chicory, executrix of the estate of Grace Miller, who's the applicant or the developer, made application to the planning board of the Borough of Morris Plains, known as the board, for a minor subdivision approval with variance relief, known as the development, on property owned by the applicant designated as Block 38, Lot 1, on the tax map of the Borough of Morris Plains, commonly known as 39 Hawthorne Avenue, known as the property owner. And whereas applicant published hearing notice in the official newspaper of the board and provided notice of the application to those required to receive the same in accordance with the law, and filed proof of publication and of service with the board secretary. And whereas the board held a hearing on the application on June 17th, 2024, reviewed reports filed by the applicant, reviewed the reports of the board engineer William D. Ryden, P.E., and the board planner Elizabeth Lahini, AICP, PP, and consider the testimony and the exhibits presented by the applicant. And whereas on June 17th, the public hearing, Anthony Bahajas,
Voyages.
Oh yeah, I'm gonna mess up all these names, I'm so
Not an
sorry.
easy one.
Esquire represented the applicant, and whereas after carefully considering the evidence presented by the applicant and the board, now makes the following factual findings and conclusions. Mr. Anderson testified as to the existing conditions on the property and the applicable zoning. He testified that the subject property is located in the R3 zone and consists of approximately 15,000 square feet. Mr. Anderson testified that in the R3 zone, minimum lot size is 7,200 square feet, measured at the maximum lot depth of 120 feet, resulting in the need for a lot area variance for both proposed lots, which contain 6,000 square feet for lot 1.01 and 5,931 square feet for lot 1.02, with a maximum 120-foot lot depth. Mr. Anderson testified that in addition to the lot variances, the application seeks the following variances as well. Minimum width of the setback as to lot 1.01, where 60 feet is required and 50 feet is proposed. Minimum width of the setback at lot 1.02, where 77 feet is required as a corner lot and 50 feet is proposed. Minimum side yard as to lot 1.01, where 8 feet is permitted and 3.8 feet is proposed to the existing garage. Minimum side yard combined as to lot 1.01, where 18 feet is required and 15.9 feet is proposed. Mr. Anderson testified that all 6 requested variances fall within the C2 classification and that the benefits outweigh the detriments. He testified that the current lot is oversized in approximately 15,000 square feet, whereas a minimum of 7,200 square feet. And the proposed subdivision, that should probably say, is required. He testified that the current lot is oversized at approximately 15,000 square feet. Oh, sorry, yeah, where a minimum of 7,200 square feet is required. And the proposed subdivision would result in the lots that are in accordance with the applicable zoning and with the neighboring parcels. He testified that the proposed application furthers goals A, C, and E of the municipal land use law. He testified that the application furthers the general welfare by allowing for infill development, provides light air and open space, and provides for appropriate density in conformance with other lots in the area. He further testified that the application furthers several goals of the master plan by preserving the established character of the neighborhood. He testified that there are minimal negative impacts in that the proposed lots will be the same size as the others in the neighborhood. The lots have more than sufficient land area, and many lots have 4 to 5 foot side yards. The applicant consented to comply with the conditions set forth in the review letters of the board engineer and planner. With regard to the applicant's request for variance relief, the board finds the following facts and conclusions. The applicant's requested variance relief as set forth results in an opportunity to improved zoning and planning for the tract that will benefit the community by allowing for development of the parcels in conformance with existing neighboring development. In addition, the board finds that the benefits of deviations would substantially outweigh any detriment. Variance relief can be granted without substantial detriment to the public good and with no impairment to the borough's zoning plan or zoning ordinance. With respect to all requested variances, the board finds that the variance will not cause a substantial detriment to the surrounding property owners. The board further finds that all of the requested variance will not substantially impair the intent and purpose of the zone plan. The development as a whole is consistent with the zone plan for the area and the pattern of existing development. The variances are not substantial deviations from the zone plan and result in a better zoning alternative for the property. Now therefore be it resolved by the planning board of the borough of Morris Plains in the county of Morris and state of New Jersey on this 15th day of July, 2024 as follows. The board hereby grants minor subdivision approval as set forth in the minor subdivision plan entitled Minor Subdivision Plan for 39 Hawthorne Avenue, Block 38, Lot 1, prepared by Paul Anderson, P.E. of Anderson Consulting, LLC, dated March 19th, 2024, revised April 24th, 2024. Variance relief for the minimum lot area depth, minimum lot width setback, minimum side yard setback, and minimum side yard combined setback as set forth above is granted subject to the following conditions. Conditions is a typo, it should be corrected. Sorry. The applicant shall comply with the May 9th, 2024 and June 3rd, 2024 report of the board engineer prior to the filing of subdivision deeds. Subdivision is in there twice, that needs to come out. Confirmed in writing by the board engineer, except for item 3 for Mr. Ryden's June 3rd, 2024 report, or as otherwise stated in testimony. Applicant will provide a copy of subdivision deed, subdivision is spelled incorrectly, for written approval by the board attorney and engineer and recorded for all required easements, if any, at the same time as the subdivision deed. Key map contained in the plan to be revised to show most up-to-date lot sizes. If any of the individual findings, conclusions, or conditions as stated in the resolution are subsequently declared invalid, the remaining findings and conclusions shall be deemed sufficient to support the decision of the board and the remaining conditions. Prior to the signing of the subdivision deed, applicant to obtain all other outside agency approvals. The board secretary shall provide a copy of the resolution to the borough attorney and to the construction official within 20 days of the date hereof. This resolution shall take effect provided by law. Have to get a certification.
No. Are there any comments from the board, everything is in order? Could we have a motion to approve the resolution?
I'll move it.
Second?
I'll second. Sorry? I'll second.
We have a roll call vote, please?
Mr. Alderwood,
Yes.
Mr. Garavaglia,
Yes.
Mr. Bezel,
Yes.
Ms. Stecker,
Yes.
Mrs. McCluskey,
Yes.
Mrs. Kelly,
Yes.
Mr. Kelly,
Yes.
Mayor Carr,
Yes.
Mr. Drexler.
Yes.
Okay, thank you.
Thank you very much.
Okay, thank you. It's good to see you.
Appreciate all of your efforts and your patience. Now I'm gonna go to McDonald's.
Want to revote?
Good night.
Good night.
Okay, so, next on the agenda is the application of McDonald. And late this afternoon, we received a letter from the attorney, for the applicant, asking that the determination for completeness be adjourned until the next board meeting, which is August 19th, 2024. And there was a question here that you made about why the agenda isn't out earlier. Very often it is out earlier, but these things are very fluid, okay? And often we don't know until the last minute how this is going to go. Actually, the applicant had sent out documents that were received very late Friday afternoon, and they were, we didn't even have an opportunity to get them to our attorneys and our experts, and so they didn't have a chance to look at them and determine whether or not this was complete or not. But anyhow, there is not going to be a hearing tonight. They have agreed to give us extra time to determine whether or not completeness has been, whether the documents are complete. So, I just wanna let you know, some of you were here last month, some of you were not. And so I just wanna kinda give you how this works. So when an application comes in, it comes into our board secretary, and they have, they distribute it to our experts, to our attorney, to our engineer, to our planner, and to any other experts that might be needed, okay? And they prepare a report to determine whether or not the application is complete. So the application is pages long, and there are all sorts of questions on there that they have to answer and provide documentation for, okay? And then our experts will prepare a report and say, this is missing, that's missing, or there's nothing missing. And if there's nothing missing, we can hear the matter for completeness, okay? And then the applicant has an opportunity to provide those documents, which have to be done 10 days before the next meeting. And that's what didn't happen here. And unfortunately, it didn't. But I'm glad you all came out here anyhow. So at some point, we will get all those documents and the application will be deemed complete, okay? And at that time, the matter will be heard. We will deem it complete and the matter will be heard, okay? And the applicant will bring in all of their experts to testify. And as they testify, the board, the experts, and our experts will have an opportunity to question that particular testimony, okay? And the public will have an opportunity to ask questions of that particular expert who testified, so. But you can't ask questions about the whole application, you can only at that time ask questions about what that expert testified to. And that's the way it'll go for every one of their experts, whether it's their engineer or their architect or their traffic expert or every single person that they put up. They will have all of their exhibits here for everyone to see. And everyone will be given an opportunity. If you want, at any time, you can go over to the annex and look at the documents that have been submitted and take your time. They're there, that's what they're there for. You can read them all. And so when everybody's has had an opportunity to testify, they will make a summation, okay? And then the board will talk about it, and then the public can get up and talk about it. And they can talk about anything about the application. It's any of their comments, they can read a statement into the record. But what you can't do is, you can't send a letter in and ask for that letter to be read into the record. And correct me if I'm wrong, the reason for that is when you are here making those statements, that is considered testimony. And the board and the attorney for the applicant, or the attorney for the applicant, has a chance to sort of cross-examine you and ask you questions. So if somebody just sends a letter in, that the expert would not have an opportunity to cross-examine that person that sent the letter in. That's correct? So, next month, we're hoping this will be on, for completeness. It could be on for completeness and hearing. That's what the attorney has requested. He will have to send out a notice prior to the hearing to everyone that's within 200 feet of the property, of any of the property lines, okay? But it's a legal notice, it'll be published. I think it's here on the bulletin board, isn't it, Susan?
Yes.
It'll be here on our bulletin board, but that's the rule. It doesn't mean that anybody else can't come. Everybody can come and make statements, and that's how it's gonna go. So it'll probably last a couple of months. There'll be a lot of testimony, I expect, and at the end, the board will determine whether or not to approve it or not to approve it. So, is that about it?
That's about it.
Yeah, I'm gonna, so you have a question on the process?
Yes, will the.
You have to stand up and, yeah, come on
Gotta
forward.
state
Tell us what your name and address is.
Hi, I'm Shivani Bill, and I'm a resident of 41 Stiles Avenue.
Okay.
Will the exhibits and testimonies be made public before the hearing, or only physically here at the hearing?
Well, whatever exhibits have been provided to the board, you will be able to see, okay, over at the annex. Now, it's possible that the experts for the applicant will bring additional, exhibits. And they will be marked in, and they will be here for you to see.
Okay, but
Okay.
they won't be like online anywhere or made public outside of this building?
No.
Okay.
Well, everything is in the annex. It's not in this
Okay.
building, it's over in the annex,
Okay.
okay? And all of that is open for the public, but, you know, it is not online,
Okay,
okay?
okay, thank you.
Yeah.
Generally, it's not available before,
Okay.
the night of the hearing.
Well, no, everything
10
is
days
available
prior.
before the night of the hearing.
10 days prior.
All the documentation.
Yeah.
Okay.
Everything submitted should be
Gotcha.
here 10 days prior.
Gotcha.
Yeah.
But it's not reviewed, so it's kind of hollow.
Well, the public can review it at any time. Anything
Yeah.
that's been
Accessible to the
submitted,
public.
Yeah, okay, but they may bring additional,
Right.
exhibits.
Okay.
That will be marked in, and they will be part of the record, okay? So, and they will be in the annex, after the meeting, if they are new, documents,
Okay.
okay?
Thank you.
Good, yeah, come on up. I'm so happy that everybody's here because, you know, normally we have no one.
Hi, Joe Licardo, 21 Idlewild Drive. So my question is on the process, following up on this woman's question before about the meeting agenda. When I went through the process with zoning, I was told with no uncertain terms, if my paperwork, my drawings are not submitted 10 days prior, there's no question I'm not gonna be heard. And we were just told that McDonald submitted Friday.
That's why they're not being heard.
They're not being heard
Well, why are
tonight.
they on the agenda that went out Friday?
Well, because we expected them to be on the agenda.
But-
Okay.
No, agreed, but if if the agenda goes out 3 days before the meeting, when their paperwork should have been in 10 days before the meeting, one would think, you don't hit the 10 days, you're not on the agenda.
Well, okay, but we have certain, time constraints, okay? So when an application is made, we have to determine completeness within a certain period of time.
Agreed.
Okay, so this has to be on the agenda tonight because we have to accept, that they have asked for an adjournment and have given us an extension of time to make a determination on completeness.
Okay, so.
Okay.
I was told I would not be on the agenda if I didn't get my stuff in, so.
Well,
Well,
Okay.
also,
Different board.
once the meeting's noticed, and you see how many people came out, I don't know that everyone would go look at the agenda, so typically it's done at the night of the meeting. Which is unfortunate for everyone who could probably be doing something else.
but it's a learning, it's a learning experience here, right?
Sure,
And-
absolutely.
and welcome to Morris Plains.
I've been here for 9 years, I'm.
Oh, okay.
Got a pool. Got a pool.
I'm working on it.
We didn't get the invite though.
It's not in yet.
I'm Joanne Dugan, I live at 31 Canfield. I just had a question about they didn't have their stuff in time, and it was on the agenda. Is there any chance that something wouldn't be on the agenda, and then we show up or don't show up, and something is being talked about that wasn't on the agenda?
Not an application.
But like
Okay.
any of the stuff to do with McDonald's, if, we don't see it on the agenda and we don't come because it's not there, and then they can't talk about it. Okay.
But it will have to be on the agenda again because we have these time constraints as far as
Right, I'm
making
just
a
saying
decision.
if something wasn't on the agenda and people didn't show up, and then it was talked about.
No.
It won't be discussed.
Okay,
No.
that's it, thank you.
Any other questions? Yeah, come on up.
Lisa Schrader, 97 Maple Avenue. So just a follow-up question on the expert testimony. So I did read their application, and a lot of the questions refer to expert testimony that would be provided at the hearing, right? So my concern is that these experts are having months to plan their testimony and their positions. The public is gonna be put in the position of hearing them for the first time, and we can't really give a meaningful, thorough response to certain things without having some time to really consider. So I guess my question would be, what opportunity is there to come back with some sort of a response or follow-up after the hearing?
Well, you can look at all these documents ahead of time, okay?
I'm more concerned about the new matter that comes up at the hearing, that nobody had the opportunity to have access to prior.
If I answer the
Yeah.
question correctly, right? She said that you could ask a question to the professional at his time of testimony, right?
Right.
And
Right.
then again at the end, when everybody has testified, if you still have a further question or follow-up, whatever, to any of the professionals.
But that's all in the same meeting, on the same day.
It could be 2 meetings later, it may be the same meeting, it all
Okay.
depends on the length of each person's testimony and the questions that
Okay.
follow.
But I guess it's theoretically possible that we might hear something and then not have an opportunity to respond like the following month after having some time to do our own sort of
I mean, that's
due
possible
diligence.
on an application of this size. I don't think it's going to be resolved at one meeting.
It's
I
not
think,
likely.
yeah, it's not likely, okay? And one thing that I forgot to mention is, so when they bring in an expert, whether it's their architect or their engineer or whoever, okay? That architect or engineer or expert has to tell the board what their qualifications are. You just can't bring anybody in. And they have to be licensed in the state of New Jersey, and the board has to determine that they will accept that person as an expert. So there's, you know, not someone coming in here and testifying that doesn't really have the credentials to do that,
Sure, yeah,
okay?
okay, yeah, it's more of a, sort of a due process sort of a thing, right? Like we are kind of at an information deficit if we're hearing something for the very first time and don't get a week to digest it or analyze it. That's really just the main concern
But you
there.
will, I mean, at
Yeah.
the end, you will have a chance to ask questions or make comments, okay?
Sure.
Yeah.
Okay, thank you.
Come on up.
Kevin Martin, 11 Maple Avenue. How many, just a quick question, just a second. How many adjournments are they allowed before the town says enough? You know, they might try to kind of make everybody just say, oh, the heck with it, you know?
Well, so it hasn't even been heard yet, so there hasn't been an adjournment, they're not deemed complete.
Well, is that what they're doing now, is an adjournment?
No, they haven't been deemed complete yet.
Right.
So
Okay.
this is preliminary to the hearing.
Yeah.
Once they start the hearing, I would imagine they're going to continue every month until.
No, well, that's
it's complete.
fine, but getting all these folks out here on the 15th of each month, especially during vacation time, you know, to wear us down, so we just say, that's it, you know, I'm done.
Sometimes you build momentum, sometimes it
Yeah,
goes the other
sometimes
way,
you
it can
do.
hurt them.
Yeah.
But I mean, if you didn't come tonight, you wouldn't have gotten all of these questions answered, okay?
That's right.
So this is our learning experience, so when we do, and again, there are time constraints, okay? So we have to deem it complete within a certain period of time, and they do not go on and on and on as far as
What
giving
is the,
adjournments.
what is the amount of time that they have to complete everything?
You mean once they start their testimony?
Once they start things, right?
As long as they have,
Well, they'll have to keep granting the board extensions if they're not heard.
Yeah.
If they're not completed in a certain amount of time.
yeah, yeah.
I don't know all the details of this application, I apologize, is it use variance? You don't know?
it's
No,
not
it's just
use
like, oh, cause it's
Yeah.
for planning board, I'm
Yeah,
sorry.
yeah.
A lot of towns are joined, so it's
Very
planning
good.
board, I'm
Thank
sorry.
you.
So, any more questions? No? Okay, then we'll move on, and what we have to do now is we have to, have a motion to extend the time for the applicant to provide the documents and to complete the completeness requirements. Did someone make a motion?
I'll move that we deem the application incomplete and we accept the letter of extension of time from the applicant.
Second?
A second.
All in favor? Aye. Opposed? Abstain? Okay, that motion is carried. So, hang around, we aren't done yet. Committee reports, we have the minor site plan committee. Any report?
No.
No, okay. Master plan review
No
committee.
report.
Okay. Next on the agenda is new business. It's an ordinance 5-2024, an ordinance of the Borough of Morris Plains, County of Morris, State of New Jersey, amending chapter 23A trees of the code of the Borough of Morris Plains. And I'm going to turn it over to Ms. Mahaney to discuss her report.
Thank you, Madam Chair. This is, she's referencing my report dated July 12th, 2024, where I talk about whether this proposed ordinance is inconsistent with the master plan. A couple of things. One to note is that this is an amendment to, as was said, 23A, trees, which is not in the land development section of the ordinance. So it's a little bit atypical to what we usually are looking at this board with regarding consistency with the master plan. The other thing to note is this has been, is being considered by the council as a requirement by the state Department of Environmental Protection. The state has, and Mr. Ryden can explain this in greater detail because this is more of his line of expertise, but each municipality with regard to stormwater and storm drains and water pollution, whatever, has an MS4 permit, and we're a Tier A MS4 permit to, basically, small municipal separate storm sewers related to both new and existing development. In order to essentially every 5 years, the state sort of adopts new rules or new regulations for municipalities to retain that permit. And new regulations went into effect at the end of 2023. And as part of that was this tree ordinance. It was something that was required by NJDEP for every municipality of a size like Morris Plains to adopt. So essentially all that we are being asked to do tonight is to make a recommendation regarding whether or not this new amendment to the tree ordinance is inconsistent with the master plan. And as I've noted in my memo, different goals and objectives going back to 2000, and I can read them here or not, but essentially, tree preservation, stormwater management, those have all been goals and objectives of the borough's master plan for the past 2 decades at least. And so this ordinance is not inconsistent with the master plan. And that's essentially what it is.
Bill, do you want to add any comments?
I don't need to add anything to Ms. Lehaney's report that she's exactly correct. This is a mandated ordinance by DEP under the stormwater regulations that have been promulgated, and every municipality has to adopt it.
So I have a question, Liz. So I'm reading through this thing and whoa, it's a lot. And at the end, it comes up with a list of trees that should not be planted, okay? So I'm into gardening, and often I will look something up on the internet, maybe I wanna order it. And are these trees going to be listed now that you can't order them or plant them in the state of New Jersey? Because sometimes I'll look something up, let's say, I think bamboo, okay?
Mm-hmm.
And it'll say it's not allowed to be shipped to whatever states.
Mm-hmm. Mm-hmm.
Do they require that or not? Or, how would somebody know they're not allowed to buy that? How would they know?
I don't know the answer to that question.
Okay.
That's something you might want to get to the council in the second reading to tweak the wording on that, if it's appropriate.
What a lot of municipalities do is they have on their website a list of plantings that are preferred and plantings, usually it's plantings that are preferred. It's easier to say what you want than all the things that you don't want.
Okay.
But, in this instance, maybe that language is appropriate to highlight on the website because that's not uncommon. Because, not just you want native species, but you also want things that are deer resistant, you want things that are gonna be hardy and appropriate for this climate and this environment.
Okay, thank you. So, anybody have any other questions? No, you wanna read? Yeah.
I actually do have
Okay,
some
good.
additional questions. So Liz, on your memorandum, in your first paragraph, you said Borough Council is considering, then down a little bit further, it says DEP requires.
Well, right, I mean, because they are theoretically considering it, you know, they would be probably in trouble if they didn't adopt it, but they're still
So it was
considering
first
it.
reading, right?
Yeah.
We didn't adopt it yet, so.
Okay.
You said it out.
All right, so that's it, I guess that's what I wanted to hear.
Yeah.
The council could vote it down if they wanted.
They could, but the DEP is essentially making it a requirement.
Exactly, okay. So, the other question, and this is more a general question, probably on process. So we all, I think, got the first copy of this back a few days after our last meeting in June. So I looked at it, and I didn't have a point of reference. So I asked Karen, who gave it to us, to say, well, I see the changes being proposed, but I don't know what the baseline was. So I was told that I could go online and look through. So it took me a while. And I did find it. And what I noticed was that within this new ordinance, or the revised ordinance, the 23A-1 is now purpose. Whereas before, I think it was tree removal. It was removal of trees. And as I went through to try to compare, and just as a side note, I don't think I should be the one comparing, right? Because I could miss something.
Could you speak up?
Oh, sorry.
I can't hear you.
Okay, sorry.
I'm interested in this one.
Okay.
Bring the mic closer to you.
Yeah. So I wanted to make sure if I was gonna provide input, I wanted to know what the baseline was, and then what the changes were. And like I said, I had to go figure it out myself. And as I was looking through, like I said, what I noticed was that each 23A-1, 23A-2, they're different now in this new document versus what was there before. And that's okay, but I still wanna know what the differences are, right? And one of the things I did notice was that, and I'm sorry, because we just got some of this information, so I have to go back and forth, and I didn't take notes, I had other things, but somewhere in there, it talks about removal of trees, and kind of to your point on what to plant and what not to plant. But in there, I think it was the old removal of trees talked about, and I'm paraphrasing, less than an acre, you can take the tree down on your property. If you have less than an acre of property, and you have an oak tree in your backyard, and you decide you wanna take it down for whatever reason, you can take it down. Now, within this, it doesn't sound like you can do that. So if you have an oak tree in your yard, if this goes through and you wanna take it down, you have to go through an application process. And that application process may deny you from taking that tree down. I think that's, and for me, that might be okay. But it seems like now the new ordinance is more restrictive. And that goes back to my initial question. The fact that it based on what your letter said, right, in summary at the back end, you said, as such, I find this ordinance not to be inconsistent with the master plan. That's great. That to me is step one. But now I want to understand what that means. Because we had a document, it seems like going to the new document, we've now changed some things. And like I said, if I have to vote on this, I want to know what that means.
Okay, can I just,
Yes,
okay,
please.
you're not adopting the ordinance, the council adopts the ordinance.
Right, but if I have to vote on that, I
You're
want to
not
either.
gonna have to vote on it. You don't vote on adoption of the ordinance. You only vote on, is this ordinance inconsistent with the master plan? And if you can find examples where you think it is inconsistent, then that's something to bring up. But your concerns, specific concerns, it's not appropriate for this board, it's the council. It's the governing body.
Okay, so is our governing body, I guess, aware of that? So now I'm a resident. So I'm not on this board, I'm now a resident. I have the oak tree in my yard that I wanna take down.
You have to go to the council. because in the best case scenario, when you get an ordinance that's an amendment to an existing ordinance, you see what's been crossed out, you see what's been added, you can see those changes, right? So we don't have that here, and you had to do that legwork. But the things that you have that are your concerns, you have to bring to the council. They wrote that ordinance,
No, DEP wrote.
or
it.
DEP wrote it, but they're putting it forth.
Yeah.
If they wanna make any changes, they have to do it.
So we are only voting on the fact that it is not inconsistent with our master plan. Okay?
Okay.
Which it shouldn't discourage you from going to the council meeting.
Right, right.
But I put the saw away for a while. Don't cut that tree down.
Or just do it at night.
Yeah. And don't let it fall on the neighbors.
And this, so, sorry. So this adoption, or this meeting for the council is this week?
Thursday.
Yeah.
Thursday. Okay.
Yeah.
Just for introduction.
No, this will be.
Oh, it's the second reading?
Yeah, it's the second reading, it's for adoption. So,
Thanks.
okay, you're welcome. See, everybody's getting an education here tonight, right?
Can I ask a question? Yeah, over there, yeah?
Sure.
My name is Margot Anderson, 38 Cutler. Why is this issue even coming up? I mean, this was something passed by DEP decades ago. Why is it only now?
No, it's just been passed by the
This is
DEP.
a
It's
revision.
new, it's a revision.
Well, why are they revising it?
Think
I mean,
council.
I don't understand why something
That worked before has to
that
be
worked
changed.
before has to change?
Yep.
I took down a very large ash tree because it was dead. And now I'm hearing from him that if I had to get
think
that
that's
ash
an
tree
exception.
down before it fell on my house.
Actually,
Yeah,
they
if
don't
it's
want you
dead-
to
I think
plant
that's an
ash
exception.
trees.
Yeah, it is.
Well,
That's an exception.
this was planted long before I bought my house 35 years ago. Okay, so I don't understand why this issue has even come up. Either here, DEP, anywhere. I'm just a little person in my house with trees, which thankfully are all alive except one, which I had to take down the other year because it was dead and might have fallen on my house. So I understand what he's saying because I read the ordinance and the change too, and I don't understand why this whole thing has to even come up.
Well, that's the DEP. That's the state government, so.
Right, but I guess I'll have to look at the Morris Plains master plan because you're gonna be voting on, is this consistent? And if you say, yes, it's consistent, now I gotta read the master plan to see why this would be consistent if now there's going to be more paperwork, presumably with fees.
The test is if it's not inconsistent, which I know is a double negative and ridiculous, but that's the way the law is written.
Double negatives are not in my line.
But it is not inconsistent in terms of the overall purpose of this ordinance is not inconsistent with the overall goals and objectives of the Borough of Morris Plains Master Plan, which talks about environmental, preservation, it talks about stormwater management,
Right,
that sort of
and
thing.
it also talks about cutting down trees.
Right, and so, but the specifics, the particulars that I think you're concerned about are sort of in the details, the devil in the details. You would have to bring to the council your concerns.
I have to do that.
Me again, sorry.
It's okay.
Joanne Dugan, 31 Canfield. Okay, so if I have a tree that's on my property that isn't an ash tree, it's not dead, and I wanna take it down, and I get denied by the powers that be, and it gets struck by lightning, and it falls on my house.
Whoa, this is way beyond.
No, it really isn't, because if I wanna take a tree down and I'm denied, and that tree, for whatever reason, falls over onto my house, who pays for that? I wanted to take it down.
I don't think this board wants to speak to the liability.
Well, then,
Disaster.
what happens if that happens to me?
Again,
You're my town.
we're only tonight talking about.
Well, I guess we're not talking about much of anything tonight.
Well, exactly.
So, where do I come
The council,
from?
Thursday is the council meeting.
So, I can ask my question at that meeting. Yes. Yes. Okay. Thanks a lot.
Any other questions? No? Okay, so let's, move on, and we will have to read the, well, read the resolution, and then we'll make a motion, yeah.
Draft resolution pursuant to municipal land use law, referral of an ordinance amending the land development ordinance adopted on first reading. Whereas the governing body of the Borough of Morris Plains has adopted ordinance number 5-2024 on the first reading, and whereas ordinance number 5-2024 is entitled an ordinance of the Borough of Morris Plains, County of Morris, State of New Jersey, amending chapter 23A trees of the Code of the Borough of Morris Plains. Whereas the governing body of the Borough of Morris Plains has referred ordinance number 5-2024 to the planning board pursuant to the provisions of NJSA 40:55D-26 concerning consistency with the Morris Plains master plan and such other matters as the planning board may recommend as it deems appropriate in connection with said ordinance. Now therefore, be it resolved by the planning board of the Borough of Morris Plains in the County of Morris and State of New Jersey on the 15th day of July 2024 as follows. Following review of the ordinance number 5-2024 and the comments of the Borough Planner at a meeting dated July 15, 2024, the planning board finds and determines that said ordinance is not inconsistent with the master plan. The board has no other comments or recommendations otherwise as to the ordinance. This resolution shall constitute the report of the planning board pursuant to the municipal land use law, and the board secretary is directed to deliver certified copy hereof to the borough clerk within 5 days of the date hereof. This resolution shall take effect as provided by law.
Okay, do we have a motion to approve the resolution? Anybody? Second?
I second.
I think we'll have a roll call vote. Susan?
Mr. Underwood?
Yes.
Mr. Garavalia?
Yes.
Mr. Bezel?
Yes.
Ms. Stecker?
I just have a question. Because we had questions about this that came up through another committee. Does that come up? I know we're voting on whether or not this is consistent with the master plan, and that's the only thing.
Correct.
So any of the other concerns, regardless of if we can make changes to it or not, are being held through the council meeting.
Right.
Okay, so yes.
Mrs. McCluskey?
Yes.
Mrs. Kelly?
Yes.
Mr. Kelly?
Yes.
Mayor Carr?
Yes.
Mr. Dritzel?
Yes.
Okay, so, is there any, old business? Seeing none? Everybody here, no more questions? No? Okay. Motion to adjourn?
Yep.
Second? Second. All in favor? Aye. Thank you for coming out.
So what do you think?